This is a very special opportunity for me and for my colleague and friend Daphné, who's seated next to me, to bring together an extraordinarily talented group to further a conversation that we've been having now for at least 7 years under the euphemism of New Battlefields, Old Laws. This is an interdisciplinary initiative that's been undertaken by the program I direct at Syracuse University called the Institute for National Security and Counterterrorism in partnership with ICT here at IDC Herzliya. We started in 2006. You all remember the Second Lebanon War. This is when the conversation began to consider the extent to which we in the academic world, in partnership now with operational experts, could begin to make progress in confronting the dilemmas that are presented by asymmetric conflicts, questioning whether the very asymmetric nature of warfare may require some adaptations to existing laws and customs of war. At the bottom, we all recognize that war, armed conflict, whatever labels we might use, necessarily require close attention to the rule of law. Whichever rule of law one settles on, whichever one is regarded as the framework, there's no doubt that any conversation about warfare and armed conflict must carefully take into consideration positive legal authority. We've been worried about these dilemmas for the entire period of our time, and over the pace of the last 6 years, we've managed to hold a number of workshops, a few major conferences here in Israel and in the United States, and we've actually produced 2 pretty good books, if I say so myself. One published by Columbia University Press about 2 years ago. Many of the authors of those chapters are here in the room today. And one published just last year by Oxford, having to do with counterinsurgency as an application of asymmetric warfare. Today, we're sort of turning the page or considering a next chapter about the effect of operational law on the law in asymmetric conflicts. We have in the room today a number of experienced practitioners from the field in the United States, in Israel, and Europe. We have academic experts from those different points of view, and we're also joined today for the first time as a formal co-sponsor in our initiative by the ICRC, who is represented here in the room. We have rapporteurs who will be carefully taking notes and detailing observations along the way today, so that later at a working lunch we can report and discuss further the kind of observations and findings that are made during this morning's workshop. So the format this morning will be further explained by Daphné, but we have two panels, 2 discussions ready to go. One is going to be more theoretical in nature, and the second will be based on a scenario, a fairly straightforward, not straightforward, but a short scenario that all of us will be able to digest and discuss along with the experts as we move through the program this morning. So without further ado, Daphné, may I turn it over to you?
Good morning, everybody. I have very little to add after Bill's wonderful introduction about the project and about the theme of today's workshop, the operationalization of international humanitarian law, or as we called it, how to enhance the symmetry between IHL and military operational art. First of all, a few announcements about the structure. Like Bill just explained, we will have 2 sessions in the morning. One of them will, the first one, will provide an opportunity for the distinguished speakers to give their understanding of very central concepts of international humanitarian law. And those 3 concepts will be, number 1, the legality of attacking military belligerents when capture is a feasible option. Number 2, how to assess what is excessive civilian harm during an otherwise lawful attack. And number 3, what is the extent of the precautions that must be taken during complex targeting operations. So those will be the three concepts that will be on which we will hear the views of our distinguished panelists, which I will introduce in a minute. And then in the second part of the workshop in the morning, we'll be discussing a scenario that was written by Professor Korn and which has puts in play essentially those very important concepts of IHL in practical situations. And finally, and this is really a very important announcement, after that we will have the wonderful opportunity to continue our discussion over a lunch, which will be taking place in a building right across the street. It's really a 2-second walk. You cannot get lost, and we will find you. You must continue and come and enjoy this wonderful lunch, during which we'll have an opportunity to draw conclusions and learn lessons from the discussion of this morning. So that is really the most, really by way of introduction. And now what I'd like to do is introduce our wonderful panel here. I'll introduce all the speakers in order in which they will be speaking, and then I'll turn the floor to them to discuss these concepts that I just mentioned. Good morning, sir. So our first speaker will be Mr. Anton Camen, who is the head of the legal department of the ICRC's delegation in Israel and the occupied territories. Mr. Camen holds a law degree from the University of Geneva. He practiced namely tax law, corporate law, and the law of torts in a private sector in Switzerland before serving as a legal officer with the district court of the city of Zurich. For the past 17 years, he's been working with the International Committee of the Red Cross, where he's been serving as a legal advisor to operations based not only in headquarters in Geneva, but also pretty much anywhere around the world, from Russia to the Balkans, East Asia, and more. So since July 2001, we've had the extreme privilege of having Mr. Camen with us here in Israel, where he heads the legal department of the ICRC's delegation in Israel and the occupied territories. And like Professor Banks mentioned earlier, we are very pleased that this year the ICRC has joined the ICT INSCT New Battlefield Old Laws project for this year's iteration of the project. So thank you very much. Our second speaker will be Lieutenant Colonel Chris de Kock, the head of the operational law section in the legal department of the Belgian Armed Forces. After graduating from the Belgian Royal Military School, Lieutenant Colonel de Kock served in the Belgian Air Force as platoon and company commander for the Force Protection Units. After 2 years of being a military instructor and after obtaining a master's degree, he taught at the law department of the Belgian Royal Military School for 5 years. He became the legal advisor from 2004 to 2007, prior to which he joined a course at the Royal Defense College, and after which he participated in the Advanced Staff and Command course at the National Defense College in the Netherlands. Since that time and up until today, Lieutenant Colonel de Kock has participated in several operational deployments as legal advisor in Afghanistan during counter-piracy and counter-narcotics operations with the Navy, and recently during Operation Unified Protector. In 2008, he took up the position as the head of the International Law Section at the Armed Forces Legal Service of the Belgian Ministry of Defense. And since April 2012, he took up the position of head of the Operational Law Section. He's also a member of the visiting teaching staff at the International Institute of Humanitarian Law in San Remo, where I saw him last September, and senior lecturer at the Royal Military School in Brussels. He's also published extensively on topics of international humanitarian law. And our third speaker will be Professor Marco Sassoli, who is currently a professor and director of the Department of Public International Law and International Organization at the University of Geneva in Switzerland. From 2001 to 2003, Marco Sassoli was a professor of international law at the Université du Québec à Montréal, Canada, where he remains associate professor. He is also a commissioner of the International Commission of Jurists, also known as the ICJ, the other ICJ. Professor Sassoli graduated as Doctor of Laws at the University of Basel in Switzerland and was admitted to the Swiss bar. He has worked from 85 to 97 for the International Committee of the Red Cross at the headquarters, among other things as deputy head of its legal division, and in the field as well as the head of the ICRC delegations in Jordan and in Syria, and as protection coordinator for the former Yugoslavia. During a sabbatical leave in 2011, he joined again the ICRC as legal advisor to its delegation in Islamabad. And he also served as the executive secretary of the other ICJ, as registrar at the Swiss Supreme Court, and from 2004 to 2013 as chair of the board of Geneva Call. For those who don't know what the Geneva Call is, it's an NGO which seeks to engage non-state actors in respecting international humanitarian law. Among many, many publications, Professor Sassoli has published what I would call today the IHL 3-volume Bible, called How Does Law Protect in War? And it's essentially become the reference point for anyone interested in international humanitarian law. Truly a remarkable publication. Last but not least, I would like to introduce Colonel retired Richard Whittaker, who has served for more than 30 years as a legal and policy advisor for the United States Department of Defense. He currently serves as a policy advisor for the United States Special Operations Command, where he provides advice and oversight over his nation's most sensitive operation and activities. Prior to his current position, he served as a staff judge advocate for the Special Operations Command and the 101st Airborne Division and the 1st Cavalry Division. He also served as senior operational law observer trainer at the U.S. Army's Battle Command Training Program, where he trained hundreds of military commanders and their judge advocates on the law of armed conflict. So you can see very extensive experience in teaching IHL to the military armed forces. Colonel retired Whittaker deployed to Iraq in both 1990 and 2003 in support of both Operations Desert Storm and Iraqi Freedom, and spent nearly 2 years in country between those two conflicts. He began his military career as a second lieutenant in field artillery after graduating from the University of Tennessee in 1982. He thereafter graduated from the University of Tennessee College of Law in 1985 and began his career as a judge advocate. In 1994, he earned his postdoctorate Masters of Law in International Law and taught operational and international law at the Judge Advocate General's Legal Center and School from 1994 to 1997. Now, I would like to tell you that Colonel retired Richard Whittaker has such a long list, has been awarded such a long list of military awards and badges, and with your permission, I won't go through all of them, but what I will do is stress once again how pleased and honored we are that you are with us today. So, after these introductions, I would like to turn the floor to Mr. Camen, who will be the first speaker this morning. You each have 15 minutes, and I will be passing you little yellow notes to let you know when your time is up. Thank you.
Thank you, Daphné. Ladies and gentlemen, colleagues and friends. So I will try in the assigned time to present the ICRC's views, positions on the three topics that Daphné outlined. But first I would like to thank also formally the organizers of this workshop for the possibility given to the ICRC, the International Committee of the Red Cross, to contribute. So the ICRC is well aware that there is an ongoing need to assess the effectiveness of existing rules for the protection of victims of armed conflict, to improve the implementation of those rules, and the point particularly relevant for the discussions today, to clarify specific concepts on which those rules are based on. Differences in interpretation of such concepts may lead to uncertainties in the application of the rules, which in turn not only makes it more difficult for commanders to work, but from a humanitarian perspective, it's likely that it negatively affects persons who have to depend on the respect of the rules of IHL. To prevent this from happening is at the heart of the mission of the ICRC, and we welcome therefore an effort like the present one that seeks to bring in some clarity on these concepts. Such efforts are all the more pertinent when considering, as the ICRC does, that the rules themselves remain as pertinent to new types of armed conflicts or ways of waging war, as they were to the types of armed conflicts when the rules were adopted, that existed when the rules were adopted. Now, this is not to negate or to deny that modern armed conflicts present complex challenges for the application of existing rules. But those challenges certainly have to be addressed, but this has to be done within the framework of the underlying tenets and principle of the existing law. That law continues to reflect a pragmatic balance between demands of military necessity and those of humanity. Now, with this introduction, I would like to move on to a few remarks on the three questions. So the first question is about attacking or killing, rather, military belligerents, combatants, when capture is a feasible alternate option. So for the ICRC, it's clear that persons who are not protected from direct attack remain within the protection of the law. They may be attacked, but the attacks themselves remain subject to legal constraints, and such constraints may stem from specific provisions of IHL, and in particular those prohibiting or restricting certain means and methods of warfare. But they may also stem from principles that underlie the entire architecture of IHL as a whole, and in particular the principles of military necessity, of humanity, as well as the famous Martin's Clause. Now, when circumstances are such that there is no necessity to kill an enemy, and hence capture would appear to be a feasible alternate option as assumed in the question, killing him nevertheless or refusing him the chance to surrender would defy basic notions of humanity. Such a use of lethal force could not be reconciled with the requirements stemming from the principles of military necessity and humanity, that no more death, injury, or destruction be caused than is actually necessary for the accomplishment of a legitimate military purpose in the prevailing circumstances. There may be circumstances when the force used against a combatant must be less harmful than inflicting death. This is, for example, the case when he can be put hors de combat by capture with no additional risk to the attacker, friendly forces, or civilians. In traditional confrontations between two opposing armies, this restriction is unlikely to come into play. Inflicting death on enemy troops in battle will generally not raise questions about the unavoidability of such harm inflicted to defeat the enemy. In such situations, it will generally be unavoidable for accomplishing legitimate military goals that force is used in first resort and combatants are getting killed. However, the question is likely to become relevant in scenarios where the attacking party has control over the circumstances and the area where it undertakes the attack. For example, when the person targeted is in a house or in a street, in a place fully controlled by the attacker, he can be captured with no additional risk to troops or civilians, and then it does not appear to be avoidable to kill him for attaining the objective of putting him hors de combat. Regarding the second question, which is about how to assess what is excessive civilian harm, maybe first I would like to mention, because sometimes it's overlooked, that the civilian harm we refer to here is not only the casualties, but also destruction of civilian objects, destruction of civilian infrastructure, because often this has a tremendous impact on the people in the place attacked. And a second point before going to the notion of excessiveness, I would also like to underline is that when making the assessment about the proportionality of which excessiveness is a part, one has to keep in mind that this assessment must not only be done once prior to the launching or deciding planning of an attack, but it remains something that's valid throughout all stages of the execution of an attack. An attack must be cancelled or suspended whenever it becomes apparent that incidental civilian harm would be excessive. Now, the assessment of the Proportionality of an attack involves determining the relative importance of the values attributed to the concrete and direct military advantage sought and the anticipated civilian harm on the other side. So this implies making a comparison of inherently very different things. There are no indications in the law as to when incidental civilian losses and damage become excessive. Few casualties and little damage may already be excessive when the direct and concrete military advantage is of relatively little importance. But it's also possible that numerous civilian casualties are not excessive when the military advantage is an important one. Now, this said, it should be borne in mind that although not specifying how many civilian casualties or how much damage makes an attack disproportionate, IHL imposes an obligation to take all feasible precautions to avoid and in any case keep to a minimum civilian casualties and damage. In addition, IHL imposes a number of limitations that reduce the scope of the advantage that can legitimately be invoked. Only concrete and direct military advantages can weigh in the determination of whether the consequence of an attack would be excessive. This means, first of all, that the anticipated damage must be military in nature. Long-term political or other advantages must therefore not be considered. Secondly, the anticipated military advantage must be concrete in the specific circumstances and time of the attack. It can neither be vague nor hypothetical. And thirdly, it follows from the word direct that merely indirect advantages cannot be balanced against civilian damages and losses. For example, the global aim of winning a war would be an advantage that would probably always outweigh any civilian harm caused. Likewise, comparing the advantage of an entire campaign and not the direct advantage of every attack carried out in the course of the campaign would inflate the military advantage beyond the limitations laid down in the proportionality rule. Moving on, because I have 5 minutes left, to the third question, which is about the extent of the precautions to be taken in complex targeting operations. I understand such operations particularly are those taking place in urban environment, in densely populated environments. I would like to mention 3 points. So one has to do with the identification of targets. The second, about the choice of the means and methods of warfare. And the third, related to advance warnings. On the identification of targets, the law requires from an attacker to do everything feasible to verify prior to any attack that targets are indeed military objectives. From the identification of the targets, this will depend on how much information the attacker has and on the quality of that information. The information must be such that the target can be positively identified as a military objective. There can be no guessing. The commentary on the rule that is codified in the first additional protocol is quite insistent on this point when it stresses that even when there is a slight doubt, an object cannot be considered as a military objective. So this means as long as there is doubt, even slight doubt, persons or objects cannot be lawfully targeted. The second issue I was mentioning has to do with the choice of means and methods of warfare. For targeting in the situations, I think the scenario we refer to here, which is related to densely populated areas, there is a particular risk for the population from the use of explosive weapons because of the close proximity of combatants and civilians and of military objectives and civilian objects. Now, depending on the impact range of the weapon used and the density of the population and of civilian infrastructure around the military objective targeted, the weapon may not be able to distinguish between the target and civilian persons and objects, and to limit its effects as required by IHL. Because of that difficulty to respect the principle of distinction, and even though there is no express legal prohibition, the ICRC believes that the use of explosive weapons with a wide impact range or impact area should be avoided in densely populated areas. Now, the third issue among the section on precautions has to do with warnings. Here I just want to underline that warnings have to be effective. They have to be perceived as such by the population. They have to leave enough time for the population to take measures to protect themselves against the coming attack. And they cannot by themselves free an attacker from taking other precautionary measures. So the fact that a warning has been given does not mean that an attack may automatically proceed. There is still an ongoing assessment of distinction and proportionality that must be made. Now, the obligations to take precautions are generally not absolute, but depend on what is feasible at the time, and this leaves a certain discretion to those who plan or decide upon an attack. So feasible precautions are generally understood as those which are practicable and practically possible, taking into account all the circumstances ruling at the time. So what exactly is practically possible, or pratiquement possible, as the French text says, depends on each situation, but it will include information about the target, its location, the weapons available, timing, control over the situation, etc. I read time out, and I'm just about finished, because I think on these topics then we can elaborate afterwards in the scenario. Thank you very much for your attention.
Good morning, ladies and gentlemen. It's a pleasure and an honor to be here. So let me first wish you a Happy New Year. And I would like to thank the organizers for their kind invitation. It's an honor to be between all those respectable and respected specialists in the framework of IHL, coming from a small nation, from a small legal department. It will be probably helpful for me as well to see to what extent other nations and other specialists in this field will interpret the same notions based on IHL. Now, I'm the chief of the Belgian operational law section, but the usual disclaimer will apply, so I will start with this one. So I'm here in my personal capacity, so any views I express here do not necessarily represent the views of the MOD or the legal department. So if you cite me on this, please cite me as being here in my personal capacity. Now, in relation to the topics to be covered this morning, it will probably not come to a surprise that, at least in relation to the first one, capture rather than kill, or kill rather than capture, that I completely disagree with the first speaker. The assumption that, that in the conduct of hostilities the parties have a legal obligation to capture rather than kill has no legal foundation in IHL whatsoever. And in general, what you see is that in relation to this issue of capture rather than kill, this is again the influence of a lot of human rights bodies and human rights activists, if I may say so, to introduce notions of international human rights law within the context of combat operations, where basically we all know, and I want to elaborate on the lex generalis, lex specialis issue, that during combat operations, the lex specialis is the law of armed conflict, and that in general there is no place for human rights law, at least not in relation to that issue. The notion of capture rather than kill is basically one of the two problematic issues which were stated in the DPH guidance. The first one being the continuous combat function and the interpretive guidance on the notion of DPH, where it was mentioned that even in non-international armed conflicts, members of organized armed groups can be targeted insofar as they have a continuous combat function. I would completely disagree with that position taken by the IRC as well, in a sense that if you're a member of an organized armed group, being a party in an armed conflict, you remain a legitimate military objective, a military target from the start of the armed conflict till the end of the armed conflict, unless you become hors de combat, in which case, of course, you cannot attack that person. But otherwise, there is no legal justification to make a distinction between the members of armed forces on the one hand and members of organized armed groups who are party to a conflict, and to limit, based on whatever notion it is, the possibility to target them based on the continuous combat function they might have. And I was glad to hear last week during the roundtable in San Remo that the French basically came to the same conclusion in their operational law section. So at least I'm not standing here alone with some other nations, but France basically adopted the same position. Now, coming back on the capture rather than kill enemy combatants, again, there is no legal justification in the law of armed conflict as it stands today, be it in customary law or in treaties and convention, where there is an obligation to capture rather than kill. If you're an enemy combatant, well, bad luck. I mean, then you're targetable during the armed conflict, again, from the start of the armed conflict till the end of the armed conflict, until you become hors de combat. And that's basically how the law stands today. If you look at state practice, be it in Afghanistan, in Operation Unified Protector, where I was deployed as a legal advisor, I would argue that state practice goes in the opposite direction as what is stated in the DPH guidance in relation to capture rather than kill. So there is definitely no customary rule which we could base ourselves up on to declare that if it's not in treaty law, at least customary law would support that position. And again, this is based on the increasing influence of human rights bodies and activists into the field of the law of armed conflict. But again, the law of armed conflict as it stands today, and it was said by the previous speaker as well, is already a balance between the principles of humanity and the principle of military necessity. So if you want to introduce human rights law in a field that is covered by IHL as a lex specialis, well, basically you're shifting the balance that states agreed when they negotiated those treaties of IHL into the direction of more humanity. And what will be the result at the end of the day? Well, the result at the end of the day will be that basically military commanders will disregard, because basically this delicate balance between military necessity and humanity will be shifted into a direction that was not agreed by the most of the parties. And so basically what happens if LOAC is disregarded by military commanders? Well, basically the first victims will be the civilian population as well. So again, and let's even assume that human rights law would be the applicable legal framework in IHL. I mean, how many provisions do we have in human rights law in order to cover targeting issues? Just one. It's the right to life provision. While IHL in Protocol 1, and most of those rules are customary, except for one or two of them, contained in Articles 48 till 60 of AP1, contain elaborate rules on targeting issues. So I would even assume that even if human rights law was to apply, I mean, human rights law is not as developed as IHL in the context of targeting issues. So again, whereas human rights law can play an additional role, because I do not agree as well that it's IHL as a whole or human rights law as a whole that is the applicable legal framework. So human rights law can play a role in armed conflict, but in relation to combat operation, the conduct of hostilities, when the belligerent parties are fighting each other, targeting is basically and only based on IHL. So again, this human rights influence in relation to capture rather than kill is, as far as I'm concerned, not a legal legal rule. Now, the second and the third issues were relating how to assess excessive civilian harm, I mean collateral damage, during an otherwise lawful attack, and what the precautions obligations are during complex targeting operations. Now, again, this brings us back to the different notions we developed during the targeting process. I would say the four most important issues you will deal with as a legal advisor is what we call PID, ROE, CDE, and the commander's intent. So PID would then stand for the principle of discrimination, of distinction, being positively identifying the target, because you cannot dissociate, I would say, the precautions and collateral damage from the principle of distinction. I mean, Article 57, as it stands today, it's pretty enveloping all the aspects of targeting, from the principle of distinction, precautions in attack, what is collateral damage, what is excessive collateral damage, and what are the precautions to be taken in order to minimize or to avoid that collateral damage. Now, let me explain what excessive collateral damage is not. Excessive collateral damage is not to be confused with extensive collateral damage. So you can have extensive collateral damage that it is not necessarily excessive collateral damage. And I would like to come back on this based on one of the famous or infamous cases before the ICTY, which was the Gotovina case, where apparently the ICTY made an erroneous interpretation of those principles, not only in that case, but in other cases as well, where basically it developed the principle of proportionality and then basically came to the conclusion that the attack was a direct attack against civilians. So it was not clear to what extent it developed the notion of proportionality and then come to the conclusion that there was a direct attack on civilians. So there is something to say on the jurisprudence of the ICTY, not only in the Gotovina case, but also in other cases. And I come back on this case of Gotovina because in one of the issues dealt with the bombing or the shelling of the apartment of Martic, who was a Serbian leader in the Krajina, when Gotovina launched Operation Storm on the 4th and the 5th of August 1995 in order to repel the Serbs back from the Krajina. And basically what the ICTY said in relation to the shelling campaign on his apartment, which was basically located in a residential area, was to say, well, the shelling campaign, having regard to the fact that it was between 7:30 and 8 a.m., if I remember well, would cause extensive or at least a significant number of civilian casualties. And by consequence, this would be excessive in relation to the military advantage anticipated of the attack. I would completely disagree with that from a legal perspective. Again, you can have extensive collateral damage, which is not necessarily excessive collateral damage, because basically if you can or neutralize or eliminate, I will use neutralize because eliminate may be too kinetic. Maybe in this case it would have been the same. But if you can neutralize the military commander of the military forces by this shelling campaign, well, I think that you could argue that even a significant number of civilian casualties would not necessarily be excessive in relation to the military advantage gained by cutting the head of the Serb armed forces in that extent. Now, again, what are the feasible precautions? And this is probably a lawyer's answer as well. It's on a case-by-case basis. It depends. Okay, there are a lot of factors that come into play because what is feasible in the framework of one operation is not necessarily feasible in the context of another operation. And that's basically the message that I gave to our fighter pilots as well, pilots who flew in Afghanistan and then were suddenly deployed to Libya, where they said, well, we know this stuff, we don't need an additional briefing on what are feasible precautions. But again, I mean, it's context related, okay? Again, like, and I take the example of Afghanistan and Libya. Afghanistan, where you're fighting a non-state actor who permanently disregard its obligations under the law of armed conflict or the law of war, does not distinguish himself from the civilian population, is hiding in civilian residential areas, whatever that can mean in the context of villages in Afghanistan, but not allowing us to make that clear distinction between who's targetable and who's not targetable. Do you have forward air controllers or joint terminal attack controllers to lead the pilots to the objective? What are your rules of engagement? What kind of operations are you conducting? Is it close air support? So those factors will, of course, influence what is feasible in the context of that operation. While in other operations, which are probably more the traditional warfare operations, such as we conducted against Libya, where you're fighting a state actor, who at least in the beginning of the campaign distinguished itself from the civilian population. That will, of course, influence the precautions you can take within your targeting process. Do you have, and that was completely different than Afghanistan, where at least there were no joint terminal attack controllers leading the pilots to the targets. So then you will have to find other feasible precautions in order to PID your target and in order to assess to what extent collateral damage would be excessive in relation to the military advantage to be gained from that particular attack. Other ROEs. So again, it's context related. Now, another issue or another aspect that will definitely influence what is feasible in the context of ongoing military operation is that you have to make a distinction, and we'll probably come back on that this afternoon, between what we call deliberate planning and dynamic targeting. Okay? During deliberate planning, it's basically pre-planned targeting, where basically you plan today and for a target that will be prosecuted within the next 72 hours. Okay? That gives you at least some more time in order to verify that the target is indeed a military objective and what are exactly the issues in relation to collateral damage and how to minimize or avoid collateral damage to the maximum extent possible. And those feasible precautions are, of course, totally different than what you can have during a dynamic targeting process, where you have basically, and again, I come back on air targeting because most of my operational background is in relation to air targeting, and I apologize for the land targeting folks here in the room. But let's assume, I mean, targeting is in the first place an air game compared to the land game, but I know that our land folks will probably disagree with this. But if you have your aircraft flying in the zone, of course, you don't have the ability to do a formal collateral damage estimation in that case. So you will need to rely on what we call a field collateral damage estimate. And again, a lot of the information and the intelligence that is available at that time will be provided by the ground force commander through his forward air controller. And again, you will rely probably as well on the intelligence from that is given by the CAOC, the Combined Air Operations Center. So feasible depends largely on the intelligence that is available at that time. And this becomes even more, so it's not, if you have to assess proportionality after the facts, again, it's based, a judge cannot place itself in place of the military commander. Okay, so the standard would be what would a normal, reasonable commander, based in the same factual circumstances, have done in order to assess what would be excessive or not excessive, and what would have been feasible or not feasible in the context of that operation. And that becomes even more difficult in the context of combined operations, because nations do not always adhere to the same conventions, to the same treaties. So basically, if you rely on information or intelligence, insofar that intelligence is released, because there is the notion of Five Eyes community. If you're not part of the Five Eyes community, you have to rely basically on intelligence, where you're not able to assess where the intelligence is necessarily coming from. So you have to rely on the allies, on your allied nations, in order to make that assessment. And again, if nations have different interpretations on what is a military objective, that will even complicate even more the assessment on what those feasible precautions are. I just ran out of time, so I will conclude here, and we probably have more time during the scenario to develop this a little bit more. Thank you.
Thank you. Good morning. Thank you to Daphné and Bill to have invited me here. You will not be surprised, as coming from Switzerland, that I have somehow a neutral position on the first issue. The legality of attacking military belligerents, the word military belligerent seems to me quite vague, when capture is a feasible alternative. I think that international humanitarian law of international armed conflict allows the killing of enemy combatants, except if they surrender or otherwise hors de combat. Thus, the principle of military necessity, which is a principle of humanitarian law, limit this permission. theoretically, according to its formulation in most military manuals, yes, it is precisely formulated in this way, but no state gives actually its forces this instruction when they are engaged against combatants in international armed conflicts. Although in reality, and there probably Chris will agree, soldiers often capture rather than kill. But I don't think it's an obligation under international humanitarian law of international armed conflicts. Now, in non-international armed conflicts, I think we have no explicit rule authorizing killing, but the law of non-international armed conflict does not either prohibit it if the target are not civilians. And here comes the controversy whether we can make an analogy with IHL of international armed conflicts or human rights does not constitute the lex specialis. I think that, no, I don't think. This is absolutely uncontroversial that human rights law requires to capture rather than to kill if this is feasible. Human rights law remains applicable in armed conflicts. I think international humanitarian law constitutes a lex specialis when targeting combatants in international armed conflicts, and in all other circumstances it depends on the degree of control over the target and the probability of enemy interference, whether IHL or international human rights law constitutes the lex specialis, and I don't feel very much left-wing when I say that, at least here in Israel, because the Israeli Supreme Court in the targeting case exactly applied this rule. And I am convinced that if a case was brought before the Israeli Supreme Court about targeting Syrian soldiers, it would not have the same reasoning. So apparently, at least here, I'm not alone. Second point, how to assess excessive civilian harm during an otherwise lawful attack. I think to calculate the excessiveness is extremely difficult to proceed to such a mathematical evaluation, which, by the way, would be essential for automated weapons. Because to an automated weapon, unlike to a soldier, you cannot say, oh, it depends on the situation, do your best, and it depends. You have to say it depends on what and how to calculate, and this is very difficult. How much is a military advantage worth? May the attacker hope for the best case scenario? Obviously, the attacker always hopes that it gets the full military advantage, but must it not also the attacker take into account that probably it will not get that? And on the other side, how much is a civilian life worth? The difficulty in this comparison is that two very different issues have to be compared. Not life against life, which would already be difficult, or damage against damage, or dollar against dollar, but a military advantage and civilian life, damage, destruction, and so on. Must the attacker foresee the worst case scenario? The probability of obtaining the military advantage and of provoking civilian losses. It's even more difficult to assess, evaluate, inquire whether IHL has been violated after an operation because you don't have all the elements, you don't have the plans, and so on. All I can say is what may be taken into account on the military advantage side and on the civilian losses side. On the military advantage side, I don't think the lives of the attacking soldiers can be taken into account because you could have that advantage even without making the attack. The issue is what's the advantage of destroying the military objective? And the lives of the soldiers, I come back to that, is an element in the feasibility evaluation of precautions, because obviously if There is a proportionality issue. I come back to that. I think one has to take into account probable enemy countermeasures, which will reduce the military advantage. An interesting question is, which arises today in counterinsurgency operations, whether you have to reduce the military advantage by considering that you lose hearts and minds among the population if you make the attack. And as a humanitarian, I would have a lot of sympathy with this approach. However, I have to be fair. As I think the military advantage cannot be too far winning the war and so on here, I fully agree with Anton. I think that the hearts and minds issue is simply too far away from this evaluation, which must be the concrete and direct factors, and not the overall policy strategy, winning hearts and minds, and so on. On the other side, civilian losses, certainly the civilian use of a military objective must be taken into account in case of dual-use objects, and reverberating effects that must be reasonably expected, and I think this develops with experience. I would think that this calculation of excessiveness, precisely because we have more and more automated processes, deserves clarification in an expert process and should be operationalized through record keeping and inquiries, including to make clear, because you know the excessiveness and proportionality is very often used as an argument where it is simply not true. But we don't know, because there is not enough transparency, and there are no independent inquiries, the results of which we would know. Then, as far as the precautions are concerned, I think the different precautions to be taken have been mentioned. The central term is what is feasible. I think this depends on the importance of the target, the urgency to neutralize it, the knowledge about the target, and the available weapons and tactics. Now, is there a duty to use precise technology? If I had a sponsor from a weapons industry, I would clearly say yes. I don't think so. There's no obligation to procure such technology, but those who have it have manifold military advantages, but have also the between inverted comma disadvantage, that they must use it when available, independently of financial considerations. But the military considerations may be that if I have a limited number of precise weapons, I may not use them in one case because I need them in the next case for military reasons, or because there are even more risks to civilians. Yes, thank you. For the benefit, these precautionary measures have to be taken for the benefit of civilians, objects, and other protected objects and persons. I don't think the protection of the civilian population, and here I will be unpopular in this room, is a common and equal responsibility of the attacker and the defender. Clearly, the attacker has the main responsibility, but the defender has also responsibility. But if the defender doesn't fulfill its responsibility, the attacker has nevertheless exactly the same responsibility than before. But obviously, if the defender doesn't fulfill its responsibility, there will be more civilians harmed. Who must take precautions? Those who have discretion on the way an attack will be carried out, but all must interrupt an attack if they realize. I think in such a system, everyone may trust that the others as long as assumption that something is a military objective. The obligation to target the object, let's say, civilian population, I don't have particular comment on that. The choice of means and methods, weapons which avoid or at least minimize civilian impact, another precautionary obligation, and finally the obligation to warn the civilian population contains an obligation to inform how to avoid the harm and must be specific enough to be effective. When do circumstances not permit warning? Because the warning rule is subject to unless the circumstances do not permit. If the objective risks to disappear, if you have enemy tanks and you give a warning, the tanks are no longer there when you make your attack. If the defense of the objective risks to make the attack impossible, if you warn and the enemy has anti-aircraft guns, and then it will concentrate all them where you attack, or if the enemy risks to use human shields, then you'd even put the civilian population into danger if you warn, because then the enemy will put the civilians around them. How to enforce the obligation to take precautionary measures there? In case of pre-planned attacks, I agree, only there. Records should be kept on precautionary measures taken. And here, again, I could imagine an expert process with practitioners to look into best practices, because I agree with Chris that everything depends. But you know, as lawyers, we know of plenty of fields where everything depends in divorce and so on. Nevertheless, we teach an entire course on that, on what it depends, which are the factors. There is a jurisprudence. Now, we hope that it will not be the criminal tribunal's jurisprudence, but rather best practices discussed by practitioners and experts which can establish a jurisprudence to clarify a little more the precautions issue and to clarify at all the excessiveness issue. Thank you.
Well, it's a great honor and privilege for me to be here, and I want to thank the Institute for the very kind invitation. And I'll just cut straight to it. The first question is the legality of attacking military belligerents when capture is feasible. Of course, as a lawyer, I keyed on the words in here, and the word legality jumped out at me, and the word feasible, as a military practitioner, jumped out at me, because that's actually a military term of art, as well as an international law term of art. And I have to tell you that initially when I read this question, I first heard about this, I was a major about 15, 20 years ago. And I thought it was ludicrous, frankly, and, you know, because we are trained and educated in terms of what Geneva III, and even though the United States is not a member of the, is not a signatory of the Additional Protocol 1, we do read it a lot. And we frankly, we generally apply it. So, you know, in terms of those two treaties, our entire understanding of our obligation in respect to this question is informed. And this question is almost an absurdity in regard to those two legal instruments. So the term legality, again, jumps out at me, and I'm thinking, what am I bound to do by the law that applies and controls this situation? And the law that we train our troops on, the law that our military practitioners are educated in, and they inform and advise commanders in regard to. And then I think in terms of the many opportunities that I've had to advise commanders and to train soldiers to conform to this rule, and how almost impossible those tasks would be if we increased the scope of when our obligation in regard to belligerents. So when I read this question, I'm thinking, well, is the obligation that this question begs to direct the commander under an obligation to shape the circumstances on some battlefield so that capture is feasible? And of course, feasible, again, is a term of art. And in fact, so I brought the definition, and let me just read this to you because I think it's helpful in this context. Feasible is a term of military art. It means the military unit has the capability to accomplish the objective in terms of time, space, resources, and tactical advantage. If any one of these four elements is not present, it is not deemed feasible. So think about that, especially that fourth element, tactical advantage. So now, does the military commander, when he's trying to draft the plan and redraft the plan, because as circumstances change on the battlefield, have an obligation to put his troops at risk to create some incredibly complex, even more complex than a typical operation order, which is, believe me, very complex. Add even additional layers of complexity to that to try to do something that's not required by the law, so that he can actually have the circumstances that afford him the opportunity to capture any enemy belligerents. My answer, of course, is no, he does not. My answer is that we should follow the law, and we'll have the best situation where we can save the most lives, frankly. If we have a simple rule that, like the one we have, which says that when the enemy soldier comes under the power of their adversary then has an obligation to accept the surrender and to care and comply with all the requirements under the Third Geneva Convention. If we try to make it more complex than that, then we'll actually do a disservice to those on the battlefield who attempt to surrender. On to the next question. And this is tough. What is excessive civilian harm during an otherwise lawful attack? And the question assumes that you have a lawful attack. And so that means that, it's a military objective. And you have, also assumes that that civilian harm is possible, so civilian persons are in the vicinity of a legitimate military objective, and so you have to pull your fulcrum out and perform that proportionality balancing that all judge advocates are taught to do when they're lieutenants, trying in what we call a simple non-complex, which there's no such thing on the battlefield as a non-complex attack, but we fasten one when we teach this to young lawyers. So, in terms of you have a direct, concrete military advantage that's derived from attacking a specific object, and then you're trying to balance that against the amount of harm that might befall civilian property or civilian lives. And it's interesting, there's no distinction made in the law in regard to lives versus property. You can look up any article in the Genevas or the additional protocols, and there's no priority given lives versus property. It's amazing, and that's not what happens in practice. We always give human life priority in actual practice, but the law doesn't require that. But to get on with this, how do you know when it's excessive? And my answer is going to be very legalistic. I'm going to simply apply humanitarian law, the law of armed conflict, what we in the United States call the law of war. And we apply that proportionality test, and we arrive at the conclusion that, when you see such damage, such loss of life that is obvious, and it obviously outweighs, and you have to also perform this analysis at the time the commander is making the decision. And the context in which the commander is making that decision and performing that balancing test on that fulcrum is he's looking at not this specific mission, he's looking at the entire operation or the entire conflict. So to go back to my colleague's example of using precision-guided munitions, if I use them now, I might not have them later. And that's exactly the context I'm talking about. The commander is making his decision with a full knowledge of the strategic plan for the entire war. Not today, not next month, not next year in terms of a protracted long-term war, but the entire conflict. And so when you look at that, what could be extensive civilian harm that occurs, you're looking at it in the long view, and again, in what's feasible, using that military term of art, what's feasible in the mind of the commander who's balancing all of this. And so when looking at the extensive damage on the ground, it may very well not be excessive. It's a very difficult term to describe, but that's about the best I can do to try to explain to you the context in which that decision is made. And the commanders always favor trying to obviously create less damage, because there's going to be post-conflict operations that follow, and the more damage they cause, the more difficult that's going to be. So not just from a moral perspective, which they apply, but from the operational perspective, they don't want there to be damage. Okay, the last question. I think this is kind of similar to the previous question. What is the extent of precautions or the obligation for precautions during complex targeting? When I first read this question, I had to chuckle a little bit because of, and I know that they're written for this kind of artificial context in here. But again, there's no such thing as non-complex targeting operations. Every targeting operation is just riddled with complexities. And I say that to provide some context here. And I'll tell you that I think that the gentlemen that have gone before me have done a very good job of laying out both sides of this. And I'm not going to point to the law and stuff, but I just wanted to give you a little bit of insight, into the mind of the military commander in terms of precautions. And one of the first things he asked, not just his lawyer, in fact, the lawyer is really almost irrelevant to this piece of it, because they're going to always satisfy the law, at least. In practice, they're always doing what the law requires. As a matter of policy, they far outstretch that. And they are asking their operational planners, okay, here's what we have to achieve operationally on the battlefield. I have to achieve this in order to move forward, and to win this conflict. But list all the things you can do to mitigate the damage. List for me all the things that we can practically do to reduce the damage, reduce the harm, and save the lives of those that are in the vicinity of where things are going to get ugly. And then the very hard work occurs where operational planners start listing things, and they consider things like, well, we could warn. We could do that, or we could use precision-guided munitions. The list goes on and on of all the different things they could do, to reduce damage. During the most recent conflict where I served as a legal advisor, Operation Iraqi Freedom, when we crossed the line of departure in 2003 in March, many of you may be aware of the capitulation effort, where we tried to think about how could we craft the circumstances where enemy Iraqi soldiers would capitulate, instead of using the word surrender or capitulate, and so we wouldn't have to kill them, and we wouldn't have to damage civilian property, and the civilians that find themselves, unfortunately, in the vicinity of the conflict, their lives and property would be spared. Because our idea was we will soon win this war, and then we will be about the business of administering a liberated land, in an occupied territory, for instance, and we want to win the minds and hearts of those that are in that land. So the more people that die, the more people we end up with their property damage. And trust me, over the next year, I dealt with a lot of those people. The more difficult that's going to be. So the idea and the framework in terms of the commander is to do everything possible to reduce damage. And the legal piece of that is always left behind, because what is actually done typically far exceeds what the law requires. Okay. Thank you.
Okay, thank you very much to all our fantastic speakers. I think this was a very, very enlightening discussion and interpretation of this concept. And again, we'll have plenty more opportunities to discuss this over lunch. I just want to remind you, for those of you who came in after my first announcement, that this workshop will be followed by a lunch during which we will be drawing some conclusions and learning some lessons from the current discussion. And the lunch will be in the building right next door. And once again, we will make sure that you don't escape and come with us for the end of the discussion. Now we have about 5 to 10 minutes, during which I'll be happy to take a few questions, but keeping in mind, once again, that the main time for the Q&A will be later on, and that I want to save the time for the scenario, which is about to begin. So maybe 2 or 3 questions, which we can take all at once if there are any questions. Yes, go ahead. Hold on 1 second. Maybe we need to have a microphone for this?
I can try and speak louder.
Or maybe you can come here also. It's okay. Speak up. Okay. Okay, no problem.
So, Professor Sassoli, you mentioned that the consideration of force protection is not relevant in proportionality. You didn't sort of delve into that. You said, well, because there's the option of like not attacking in the first place. But I would suggest that it's more complicated than that. There are many circumstances where force protection can be very relevant, and I would suggest in actually most circumstances. Perhaps, I mean, I'm inviting you, but also some of the other speakers perhaps have something to say about that point, because I think it's quite an important one.
Okay, before I just turn it to the speakers, are there any other questions, perhaps? Yes, Greg, go ahead.
I'd like to raise the matter of civilian shields and whether they are subsumed into combatants directly participating in hostilities by reason of their activity in protecting the target. So I noticed also that Professor Sassoli referred to them as civilians, and whereas there are important considerations about hearts and minds and civilian casualties, I think legally the question remains as to whether they don't become subsumed into combatants. And I'd like the panelists to consider that point.
Okay, those are 2 great questions. I'll turn it to the panelists and then we'll take a break. So whoever wants to address the 2 questions. You have, in any order, it's okay. Professor Sassoli.
Otherwise, I can also speak loudly, because when I teach to 400 students. So first, on the force protection, don't misunderstand me. There can be operations where the very objective is to save the lives of some soldiers, for instance, to get them out of a situation, and there this is the advantage, and therefore clearly it counts. But in most operations, the objective is to destroy a military objective, and then it would be absurd if I could say the more soldiers I use, the more civilian incidental damage I may provoke, because then I save their lives. If the advantage is very small and I risk many civilian lives, I cannot change this proportionality by using more soldiers, so that I then can say, as I use a lot of soldiers to protect their lives is an additional military advantage. While in most cases I come to the same result than you, because I would say in the precautions phase, there indeed to say, shall I make an additional verification, or shall I use this tactic or that tactic? There, the lives of my own soldiers are part of the feasibility evaluation, and if I risk the lives of my soldiers too much compared with the importance of the objective, then this additional precaution is not feasible. For human shields, they are civilians, except if they physically block, for instance, a bridge, because then they directly participate in hostilities. But if they are simply on the roof of a building, the building can nevertheless be destroyed. And the target remains a legitimate target, and this is uncontroversial as far as involuntary human shields are concerned, while it's controversial, I have to admit, for voluntary human shields. The problem is, I don't know, Chris, how does a fighter pilot determine whether the wife of a Taliban is voluntarily married with that Taliban or has been obliged to marry him? Which would be the difference between a voluntary and an involuntary human shield. And therefore, I would stick with it that to be a human shield is not to directly participate in hostilities, except if you hinder with that physically a military operation, not morally or legally. Thank you.
Thank you. I think Mr. Camen wants to add something. Yes.
Is it working?
Yes, it's perfect.
Yeah. Sorry. Maybe just to to add on the force protection issue. I mean, I obviously agree with Professor Sassoli's statement about that in a proportionality assessment, the force protection would only come into play when the objective of the attack is the protection of the forces themselves, but not when it's different. One and also on the thing Professor was mentioning about basically the identification of targets on to how much certainty, to what degree of certainty a target must be positively identified as a military objective. But one thing I would like to add is when thinking about the choice of means and methods of warfare. So it's clear that the protection of the forces would never justify a disproportionate attack, because disproportionate attack would be prohibited anyhow. But the problem is when the attack would be actually proportional, and then there is a chance within or respecting proportionality to reduce or to allow a reduction of civilian harm. And this might have an impact on risks that soldiers take or not to further reduce this civilian harm while being proportional anyhow. And there I think military commanders probably would make an assessment of that risk that soldiers would take, or that risk of, could be excessive compared to that further reduction of civilian harms. And this, I think, is a question that is not decided and probably deserves qualification. Then I just have to respond to Colonel de Kock. Because he introduced his speech and you know that he fundamentally disagrees on the capture and killing, and maybe just to clarify, because basically I agree with him. Yes. No, the thing is, I mean, he made first just two points. I mean, the first is that I did not say, and we as the ICRC, we don't say that there is a legal obligation to capture rather than to kill. And I try to make it clear that there are certain circumstances, certain specific circumstances that normally in a typical combat situation don't pose any problem at all. But certain circumstances when attacking troops are in full control over a place where it simply would not make sense to kill a combatant, and there we would say, and I know of course it's a very controversial topic and it's discussed over and over again, but there for reasons already of, I mean, it's militarily simply not necessary to kill because the person could be captured. And I think in practice probably he actually would be captured in many instances because simply it's not necessary to but those are exceptional circumstances. And the other thing where I also agree with him, and which I didn't say at all, is about the human rights part. I mean, while agreeing, of course, I think, and okay, that human rights doesn't simply stop because there's an armed conflict, but in combat or let's say military operations, in hostilities, of course, IHL primes, and this limitation of capturing or killing would be an eminently humanitarian law or law of war consideration from our side. So it's much more from other, I don't know, writers that would bring in a human rights dimension. And the concern is precisely that, you know, that these rules of IHL, they must be practical and they must serve. I mean, of course, the victims, but in the end, they would serve the victims of armed conflicts when they can practically be applied by the military. So I just had to make that point.
That's
Thank
okay.
you.
Thank you, Tony. I think this is a good time to actually conclude this first session, and I would like you to join me in thanking the members of this panel for this very interesting panel. Once again, we'll explore the implications of these very different interpretations of what these concepts of IHL mean, both for their implementation in operations, but also for legal scholarship later on. So now what I suggest is that we just get organized for the second part and the discussion of the scenario, which you've all received on the tables. We'll reconvene in just about 5 minutes. If you want to get a coffee, I'll see you in 5 minutes right here.